so I don't get hoarse. But their bios are in your program, and this is a phenomenal program. And I want to thank the Federalist Society on behalf of all 5 of us for having us here. I want to give you just a couple facts about each professor, and then we're going to go right to their opening remarks, which will last 8 to 10 minutes. Professor McConnell's already protested the time limit, but I will keep the time limit. Maybe he won't protest if the mics don't work. And then after that, we will skip my questions, go right to your questions, because we've been trying to get the mics working, and we ate into a little bit of the time. So Professor Flaherty is the first professor, and he's from Fordham Law School. And just a couple neat facts about him. He co-founded the Rule of Law in Asia program, and that in particular supports Chinese lawyers. And he's currently writing a book on foreign affairs and the Supreme Court. And the first part of it focuses on the founding and originalism. And I think it's fair to say, although he can correct me, that he is dubious that the vesting clause can grant powers to the president. The second professor is Professor John Yoo. And I think we are making history today in that at a Federalist Society convention, we have 2 people from Berkeley on the stage. I don't know that that's ever happened.
Who's the other one?
Oh, him.
The second thing,
It's like, who's the other one?
the second thing is we used to talk about some of the memos that John worked on at OLC, but now everyone here was about 7 years old when you worked on those memos, John, so I don't know that they know much about it. The third professor is Professor Prakash. Oh, and Professor Yu's, of course, from Berkeley. Professor Prakash has written extensively in this area. One of my favorite things, if you haven't read it, is he and Professor Yu debate the Declare War Clause in Article 1, and their law reviews on this are fantastic. The little-known fact about Sai is that he's an avid moviegoer, and he loves superhero movies. And this morning, I bumped into him in the gym, and he had a superhero T-shirt on.
It was a T-shirt with a picture of me.
That's right.
My hero. Very good.
Now, finally, a lot of you know Professor McConnell as a professor that writes thoughtful and engaging law reviews. And if you haven't read his originalist defense of Brown, it is definitely worth reading. I want to tell you just a couple facts about him that you may or may not know. He was a superstar 10th Circuit judge, and my clerks now will bring me this opinion, and they'll say, Judge, there's this great opinion from this guy McConnell from the 10th Circuit. Do you know who he is? And you look, he's shocked that my clerks don't know who he is, and but they're always awesome and worth reading. Maybe more important thing is he's now written what I'm convinced is going to be one of the original or leading originalist pieces on executive power. And I thought it was a law review, and I had it bound because it's so long and thoughtful. And my wife saw me reading it. She said, "What book are you reading?" So I'm going to try and convince him, if he hasn't already decided, to turn this into a book that'll be must read. And with that, we're going to start with him. And if all of you, when you read their bios, one thing you're going to be convinced is you're going to say, this is just a superstar, rock star panel, and how, as a law student, am I ever going to do what they do and have the brain power they have? And what I would tell you is, if you don't worry. You can always be a circuit judge like me.
Well said. Well said.
So, thanks for. Can people hear me? No mics. My goodness. Oh, they are working now. So this is on. So the topic that we have been assigned is a question: the executive power, prerogative versus delegated powers, a king minus powers given to Congress or subservient to the legislature. Somebody who doesn't have a really euphonious sense of the English language must have written this title. But I'd like to give you the answer first, and then revise and extend my remarks. The answer is some of each and a little bit of neither. So we have to begin, as of course, in Philadelphia, at the Constitutional Convention, and constructing the executive was possibly the hardest thing that they had to do. Now, the big state, little state thing was very difficult, but that was really a political compromise. Figuring out how to have an executive that would be energetic, vigorous, and independent, but not dangerous was a pretty hard thing to do. As Benjamin Franklin pointed out on the second or third day of debate, he said, looking over at George Washington, who was there, who was presiding at the convention, he says, the first man at the helm will be a good one. We don't know about those who are going to come thereafter. More prescient words were never spoken. The rough draft of the Constitution, the Virginia plan, mostly written by James Madison, had an extremely sketchy executive. It essentially assigned, quote, the executive rights, unquote, of the Confederation Congress to the president. And this meant essentially all of the executive power would go to the president. And Charles Pinckney, the second youngest delegate there, basically he goes like this. He says, why, that'll make him a king. It'll make him a monarch of the worst kind, an elected monarch. And the reason he thought that, he said, was because it would give the president the powers of peace and war. Now, why would he think that? He thought that because the powers of peace and war, the power to go to war and the power to make treaties, including treaties of peace, were prerogative powers of the king in Britain. And when all the executive powers of the nation were to be vested in the president, it was a logical inference that they would be among them, and that was something not only Pinckney, but almost no one at the convention could live with that. Even Hamilton, the most pro-executive delegate there, did not believe that the president should have the entire powers of peace and war. And so they went in a couple days, June 4th, they go to the opposite extreme, and they enumerate three and only three powers for the president, namely to execute the laws, to make appointments, and even not all the appointments, most of the appointments, and to veto. And then they don't return. That's a very weak president, right? And they don't return to the subject until the last half of the summer. And the rest of the work on the devising the executive power, working out all these difficult problems, was done behind closed doors, essentially in three committees, mostly the Committee of Detail, but also important contributions from the Committee on Postponed Matters and the Committee of Style. But we have no real records. We have some successive drafts within the Committee of Detail, but we have very little information about what went on. And so all we can do is sort of piece together what their theory of the executive branch was from what they did. So let's talk first about the Committee of Detail, because that's the most important thing. And of the five members, James Wilson of Pennsylvania and John Rutledge, who was apparently the chair of the committee from South Carolina, seem to have been the dominant figures. Both of them made speeches in favor of a more powerful executive, but making it clear that the president would not have all of the prerogative powers of the king, and then so the Committee of Detail carries out that project. I can't give you all the evidence, but I mean it's a long project. But let me give you some of the conclusions about what I think they were doing. Essentially, what they do is that they have a classification system of the nature of powers. There are some powers that are strictly legislative functions that must be carried out by the legislature, and indeed I think they can't even be delegated by the legislature to anyone else. And those powers are essentially the power to enact legally enforceable rules for the governance of the people and their property, note the close connection between that conception of the legislative power and the Due Process Clause, which says no person may be deprived of life, liberty, or property without due process of what? Of law, and law being defined in the Supremacy Clause as the acts of Congress. So the executive cannot do that. If you're going to deprive someone of life, liberty, or property, which essentially means enacting rules to govern themselves or their property, has to be done by the legislature. And the legislature will have the power of the purse. That is the power to tax and to decide where the tax dollars are going to be spent. So these core legislative powers are going to be in Congress. And then there's another bucket of governmental powers which they understood to be strictly executive. James Wilson tells us the only powers which are strictly executive are the power to execute the law and to make appointments. Note that not all the appointments even are within the purview of the president in the early drafts. Well, what about everything else? Governments do a lot of things other than make police power type regulations of people and property and appoint and so forth. There are things like who decides about war? Who conducts the war? Who decides about peace? Who makes treaties? The whole area of foreign affairs seems to naturally fall in neither of these buckets. Now, John Locke wrote that these external powers, war and peace and foreign affairs and so forth, he gives them the uninformative label of federative powers. The label doesn't matter, but he says that they are not inherently part of the executive, but for reasons of convenience, really it goes a little bit deeper than that, but reasons of convenience, they are almost always assigned to the same officer who has the executive power. So this whole body of foreign affairs powers tends to be executive in fact, even if it isn't inherently executive in nature. But there are lots of other powers too that don't fit in either of these, either strictly legislative or strictly executive buckets. Finance, for example, borrowing money, coining money, and so forth. I have a long list here, but the time is going. So, what are they going to do with all these powers? And the answer is that they parcel them out, giving some of them to Congress, and they give some of them to the president. And what they're using for their model, their list of these powers, is that they're looking at Blackstone. And Blackstone has, depending on how you count them, maybe 42. That's not because you don't know whether some of them are one or two. But, roughly speaking, something like that, powers that are labeled executive prerogative powers of the king. And every single one of the powers discussed and listed in Blackstone, with one exception, every single one of them is expressly allocated in the Constitution, either to Congress or to the president, or in some cases to nobody at all. They're not going to be titles of nobility. We're not going to have the monarch's prerogative powers over the Church of England are not going to exist. So some of them aren't going to be exercised at all, but every single one, with one exception, the removal power is the exception, are allocated expressly to either Congress or to the president. A lot of them go to Congress. So these are powers exercised by, exercised by the king, and they are given to Congress. 13 of Congress's 29 powers, again, depending on how you count, were actually powers of the king, not heretofore exercised by the legislature. And then some are given to the president. What this leads to, when you then look at Article 2 and how to classify the powers granted, is that there are certain powers that are in Congress's total authority, and the president cannot act without the advance authorization of Congress, and he has to carry out what they're doing. What are these? You know, obviously criminal laws are in that category. Taxation, spending, borrowing, and going to war are among the most important of those. The president cannot, on his own initiative, simply step out and act in those areas. The precise definition of starting a war is something I don't have time to talk about, but many pages have been devoted to that. Then there's a second bucket of powers, the prerogative powers that are allocated to the president expressly, and they have prerogative status. They're understood to be prerogative powers. What that means is that the president has them by virtue of his office through the Constitution, and Congress can't take them away, and Congress can't tell him how to exercise them. And then there's a third category of powers, of which many foreign affairs powers, in my opinion, are among these, that are in this intermediate category, neither strictly legislative nor strictly executive in nature. And it is my position, I have to argue this, there's evidence for it. Martin Flaherty may disagree with this. In fact, I know he partly does. That these are given to the president through the vesting clause, the first sentence of Article 2, but they are not prerogative powers. And that means that when Congress is acting within the scope of its delegated powers, the Congress can override the president. They can take them away, they can regulate them, they can tell him how to exercise them. That means, if this is correct, among other cases that you've probably studied in law school, Zivotofsky, the recent Zivotofsky case, was wrongly decided because although the president does have the power to recognize foreign governments as part of this unenumerated executive foreign affairs power, so long as Congress has an enumerated power to regulate passports, which was the issue in that case, that overrides the president's authority. There's much more to say, but the judge is likely to gavel me down if I stay up here any longer.
The Federalist Society has to get us a gavel.
Well, gratitude to the Federalist Society and, of course, to the Georgetown chapter for putting on a wonderful conference. I had the pleasure of attending a conference at Stanford when I was an undergrad back in 1989. It was a student conference on affirmative action. It was wonderful, and it left an impression that stayed with me ever since. So I'm really glad to be here today. When we focus on presidential power, the first thing that comes to mind is the vesting clause. It inaugurates Article 2, and it says the executive power of the United States is vested in the president. And as Justice Scalia told us, it's all the executive power of the United States. And then we could add a modifier, except for the provisions that delegate the executive power elsewhere and subject to the exceptions in the Constitution. It was understood as a general grant of power at the founding. Washington said as much, Jefferson said as much, Madison said as much, John Jay, the former Secretary of Foreign Affairs, said as much. The first Congress implied as much in its statutes that created the Departments of War, Foreign Affairs, and the Treasury. And the Supreme Court has said as much in some of its cases. And then finally, of course, Alexander Hamilton said as much. What did the vesting clause include? It included authority over law execution. That was the quintessential executive power, as Michael pointed out. It also included foreign affairs authority. Although Locke said foreign affairs wasn't necessarily executive by the time of Montesquieu, Montesquieu characterizes foreign affairs as an executive power. The Continental Congress is understood as an executive institution, primarily because it exercised and wielded executive power over foreign affairs. And there are various American documents during the critical period that identify foreign affairs as an executive power, including the conversations that Michael identifies at the convention. Why did they grant the president this sort of generic executive power and then qualify it in various respects? Well, this was a common device in constitutions. Madison says in the Federalist Papers, nothing is more common to grant a general power and then to qualify it in various respects. Hamilton, of course, says that later on as Pacificus in the Pacificus-Helvidius debates. And the state constitutions adopted the same framework. They would grant generic executive power and then subject to various exceptions. And so this was, even though it might seem odd to us today, it was very common in the 18th century. How did we get there? Michael started with the convention. I think if you broaden the scope a little, you can see what's going on in American history. At the Revolution, in the Declaration of Independence, people are very angry at the king, and if you look at the Declaration, it's basically an indictment of kingly power, right? He's done this, he's sent, tax collectors, he's created offices, he's doing all these terrible things to us, and basically it's a litany of complaints against the king. And the reaction to monarchical power and gubernatorial power, the royal governors were also a problem, led to very weak state executives. When the Continental Congress asked the state legislatures to create constitutions, the states did so, and they created rather weak executives. How were they weak? They were often plural, right? In Pennsylvania, it was an executive council. There was no unitary governor. In Virginia, there was a governor, but it didn't mean much because he had to run through an executive council, so you had sort of nominal unity, but actual disunity. These folks could only serve for a year in office. They often were unable to serve again. They lacked a veto power. They lacked effective appointment powers. So they had taken the idea of an executive and sort of fragmented and dispersed the power, creating very weak state executives. Madison says they're ciphers, meaning that they're non-entities. They don't have much authority. And they did one more thing. In the state constitutions, they said that the legislatures could modify the grants of authority found in the state constitutions. So whereas, while the state constitutions granted various executive powers to state executives, those grants were subject to be modified by state legislatures. So you create a weak executive, then you give the legislature authority to modify the executive's powers, and you get very weak state executives. So for instance, the South Carolina governor had a veto under the 1776 state constitution. The legislature passes a new constitution in 1778 that takes away the veto. The governor vetoes the constitution. They ignore the veto. That shows you how weak they are, right? The guy's got a veto, and they just say, well, that's interesting, but we don't really have time for your views. So, they've got this very weak executive system, and the founders understand this. They say we were sort of inexperienced in the science of government. We reacted to the kingly authority. We went to an extreme of creating weak state executives. If you look at the federal level, the Continental Congress, as I told you earlier, was primarily a federal executive. It didn't have much legislative powers and had very limited judicial authority. And it was a bad plural executive. It was an executive by committee, where people always weren't at the nation's capital, right? So you had delegates coming and going, and they often served for very short periods of time. They didn't think that a plural executive was a good idea. They eventually created departments, executive departments they called them, including the Executive Department of Foreign Affairs. And they tried to have individual officers called secretaries supervise those departments. And that was an improvement, but it wasn't enough because Congress could dictate to them what they ought to do in their various departments. These weren't independent executives. They were creatures of Congress. And so by the time of the Philadelphia Convention, there is a revolution. It's a counter-revolution, right? You've got the reaction to the king. We create weak state executives. You've got a counter-reaction by 1787. We need a stronger federal executive. We need an independent executive. And that's why when they get to the convention, even though there are some people who want to create a triumvirate or a plural executive, many more people want to create a unitary executive. And that is a decision fraught with controversy and consequence, right? Edmund Randolph says that's a fetus of a monarchy. If you create a unitary executive, you're going to have a monarch. And other people sort of embrace that. There are delegates who say there's probably 20 delegates at the at the Philadelphia Convention who favored a monarchy of various sorts. And so they create an executive that's, as you know, unitary, that can serve for 4 years, which is very long in terms of the state constitutions. The longest term there was 3 years. They're re-eligible. And they had an experience with re-eligible executives. In New York, the governor was re-eligible, and he got elected 5 straight times to serve a total of 15 years. They thought if you made the president re-eligible, it was quite possible the president would serve for life. We don't see that because Washington chose to step down after 2 terms, and other presidents until Roosevelt honored that tradition. There's also no executive council, or there's no generic executive council. So they created this very strong executive. And when the Constitution was sent to the states, people beheld a king. Thomas Jefferson said it was a bad edition of a Polish monarch. John Adams said it was a Republican monarch. The Dutch stadtholder said you've created a king with the title of a president. And of course, the Anti-Federalists said the same, that this is basically a king in name. And it was an elective monarch, right? It wasn't a hereditary monarch. We don't recognize that as a species of monarchy. But if you go back in ancient history, there were elective monarchs. The Polish king was an elective monarch. That's why Thomas Jefferson said it's a bad edition of the Polish monarch. The Pope was an elective monarch, still is, over a very small portion of land. Of course, the Pope used to control more land. So I think once you understand that there were many flavors of monarchy, they weren't all absolute, and there were elective monarchs and there were limited monarchs, like the King of England. What did Montesquieu say about the King of about England? He said, England is a republic disguised as a monarchy, because the king was a limited monarch, right? And he was basically suggesting that we have to understand monarchy and republic along a continuum, and if we understand it as such, if we don't just focus on an absolute monarch, we will see that England has elements of a republic as well as of a monarchy. So they thought they had created a king, at least several people did, and of course the Federalists tried to deny this, but they did this in part by downplaying the authority of the king and downplaying the authority of more limited monarchs in Europe. But what John Adams said, the president has more power than many crowned heads of Europe. And that's probably why people like the Dutch stadtholder said this person looks very much like a monarch with the title of a king. What about Congress? I agree with Michael that Congress has a good share of executive powers, as it did, of course, under the Articles of Confederation. Right? Congress has the war power. Congress creates offices. The president generally cannot create offices. Right? If the president wants to have a new office or department, he has to go to Congress. The Senate, of course, has checks on 2 exercises of executive power, the treaty authority and the appointment authority. And so Congress, is in a sense still a plural executive if we use the 18th century categories. What about Congress's authority over the president? Michael talked about prerogative. I think the way to think about our Constitution is not to use that concept, but just ask the question, does Congress have authority over a particular area? If it does, I think Congress is primus inter pares. Its laws take precedence over presidential desires. So if there's an area of shared authority where Congress has legislative power, the president has to comply with the statutes. But if Congress doesn't have legislative authority and the president does, Congress loses. And I think so when you ask the question, does the president have to honor the statute, the question ought to be, does Congress have authority over the area? If Congress doesn't have authority over passports, the president doesn't have to honor it. If you look at early history, Congress didn't regulate passports until the 19th century. The president issued them unilaterally, I'd say under the foreign affairs powers that he had. But that's the question, does Congress have passport authority? There's nothing in the Constitution that speaks to passports, right? So you'd have to infer it from something else. My time is up, but I look forward to the comments and questions you folks might have. Thank you.
Okay, well, thank you again to the Federalist Society and to Georgetown. Can everybody hear me? Okay. So I'm going to be concentrating mostly on the executive and foreign affairs and to the extent the judiciary. And with the executive and foreign affairs in mind, I think we should appreciate and indeed applaud the challenge of someone going to a potentially hostile environment armed with only the truths of the American founders and a long-shot hope of a productive outcome. And I figure if President Trump can go to Pyongyang, I can come here. Actually, I should say I have had a wonderful time at the many Federalist Society events. I've been to many with John Yoo going back at least 10 years now. The Federalists throw a much more lavish party than the American Constitution Society. So, sorry. I know I'm going to get in trouble for that, but. So, my training was initially in history. I went to history graduate school until I realized that you can make twice as much money doing half the work as a law professor as opposed to a history professor. So off I went to law school to become a law professor. And I thank the judge very much for the plugs. Many of my remarks are going to come from an upcoming book that Princeton University Press is going to publish on the Supreme Court and foreign affairs. By the way, I need a title for this book. Diplomats and depositions, opinions of the court and special ops, none of those really work. So if you can come up with something better than just Supreme Court and foreign affairs, I'd appreciate it. But the main thesis of the book, and it's relevant to today's discussion, I hope, is that the judiciary has an important place in foreign affairs, including checking the political branches, including and especially checking the president. And in part, the flip side of that is that the president does not have undifferentiated, broad foreign affairs powers. So I derive both propositions, the judicial side and the executive side, from two stories commonly told about the founding but are often not fully integrated. One is the foreign relations story and the other is the domestic separation of power story. One person who did integrate both of those stories is none other than this fellow whose profile you see here, Madison and Vices of the Political Systems of the United States, which was the seminal document leading to the Constitutional Convention, integrated both problems, the foreign affairs problems under the Articles and also the pathologies that were occurring on the state level. So let me first talk about what in scholarship is the more familiar story, really going back to the magisterial work of people like Gordon Wood and followed by scholars like Jack Rakoff, which is that separation of powers in our familiar American sense was both the diagnosis and the solution to the concentration of legislative power in the early state constitutions. You heard elements of that both from Professors McConnell and Prakash. And that's certainly true. I could go back further, but I don't have the time to talk about the English Whig mixed constitution. But certainly, for all sorts of reasons after independence, the initial move in most state constitutions was to accrete legislative power and concentrate not just legislative, but what we might characterize as executive and even judicial power, or at least control over those other branches in ways that you've heard to the legislatures. Madison would later say, legislatures everywhere are amassing power into their impetuous vortex. I think that's Federalist 48, 47 or 48. Now, separation of powers was a diagnosis to that problem because concentration of power in that sense led to an assault on various liberties. And the diagnosis and the solution led to separation of powers in at least two senses. One was indeed enhancing the power of the executive. As well as, what I'll talk about in a second, enhancing the powers of the judiciary. But enhancing the powers of the executive does not mean that there was an embrace of almost some of the kingly versions of executive power that some who are associated with the Unitarian school of executive authority tend to put forward. And in this regard, I just want to make several points to be skeptical of that particular conception of the founding view of executive power. One is, and if I had more time, I could develop this more, separation of powers, surprisingly, was a rather new and underdeveloped doctrine insofar as it was central to American constitutional discourse in the 1770s. For the previous century, most American constitutionalists were English constitutionalists, which meant they weren't thinking primarily in terms of separation of powers. They were thinking in terms of English Whig mixed government, which is tripartite, but tripartite in a very different way. And separation of powers didn't come to the fore, even though various scholars had talked about it, until the 1770s. And so the point there is it is comparatively new and thus comparatively underdeveloped, and there is going to be all sorts of substantial disagreements about it from all sorts of quarters outside of the very basic general principles of separation of powers, which is legislatures legislate, executives implement the law, and judges adjudicate. One example, to cite an example that Justice Scalia was famous for in Morrison versus Olson, he liked to cite separation of powers clauses from early state constitutions, including the Massachusetts Constitution of 1780, which says the legislature shall only legislate, the executive shall only exercise executive power and not judicial, et cetera, et cetera. Now, that is often taken as an acknowledgement of this well-understood body of undifferentiated executive power, that executive is a well-known label for a mass of powers that would have commanded a consensus at the time. Just not true. And one example of that is the very same Constitution, the Massachusetts Constitution of 1780, assigns the appointment of militia officers to the executive? No, to the legislature. And it's not because it's an exception to a commonly understood baseline. It's because they were still working out the details of this relatively new system. Now, in terms of the prerogative, actually I'm very sympathetic to Professor McConnell's approach. And I think the prerogative, and looking at the prerogative, gives us all sorts of insights, and it's a good way to approach what was going on. I have some disagreements. One is, the prerogative doesn't necessarily automatically translate, which is a concept ultimately derived from English constitutionalism and Whig mixed government. It doesn't automatically or even easily translate into separation of powers. And I think Professor McConnell acknowledges that. Nonetheless, I'm largely sympathetic to his account, even though we have certain disagreements. So one point about the adoption of separation of powers is it's underdeveloped. Two is, with regard to executive power, there is still an ongoing mistrust of executive power that you can see in many of the statements of the founders. The resistance that led to the American Revolution was largely resistance to Parliament, and ironically, most American patriots proclaimed fidelity to the monarchy. Nonetheless, they were steeped in a century of English Whig constitutionalism, which basically expressed great distrust of monarchical power. And that didn't just go away in the reaction to the early state constitutions. One third consequence of the domestic separation of powers story, getting to my other side of what I want to talk about, is enhancing the judiciary. The power of the judiciary, which was also very weak in the state constitutions, which meant life tenure, which meant salary protection, and which in many states led to pioneering efforts to develop judicial review. All right, let me turn to the foreign affairs story. This is the story, ironically, that most of you probably learned in high school, which is we were the 98-pound weakling on the world stage, and France and Britain, everyone's kicking sand in our faces. And so, under the Articles of Confederation, we needed a stronger federal government. Now, the most dramatic example of that was the inability of the United States under the Articles to uphold our treaty commitments, not least the treaty of a peace treaty of 1783, and I'm running out of time already. But here, what I want to say is that's often told as a federalism story. It's also a story about executive power. And here the story about executive power is, well, in part, we get a stronger national government, and then, of necessity, we need to give a lot of power to the executive branch. Well, if my new book makes a contribution, it is going to be this. It is that the same concerns about fracturing power where there was power with regard to domestic power, which was initially a reaction to the legislatures, that is also a concern in foreign affairs. And separation of powers applies fully in foreign affairs as domestic affairs. The one final thing, I'll skip over what I was going to say other than to make two final points. With regard to the notion that executive power was a code word for a large body of undifferentiated foreign affairs powers, my colleague Kurt Bradley and I went through just about every document we could think of in the 18th century that dealt with these matters. We only found two statements where individuals actually said executive power means foreign affairs power. One was Hamilton in the Pacificus Papers, but only after he made very clause-bound statements about executive power, and the other was a founder who I think you will all view as dispositive, Egbert Benson, a congressman from New York. They're just, and it is stunningly not there. There is no there in terms of that proposition, and it's only by projecting onto that word modern conceptions that you get this notion that the 18th century believed that foreign affairs power equaled executive power and vice versa. And I think I'm well over time now, so I will end there and look forward to the debate and questions. Thanks.
Well, I have to say I'm very confused to be here because I was leaving the People's Republic of Berkeley, and I arrived at the airport, and I asked the cab driver to take me to the White House counsel's office for judicial selection, and he brought me here. It's really a great pleasure. I promise, like the list of reasons to have steel tariffs, I will be short. But I do have to take issue with Marty. Marty wants to know why are Federal Society events better than ACS events, and I thought he was at the party yesterday, so he should have taken away the key lesson, free alcohol and free food, which I've never seen at any ACS events, which is actually the real reason I don't go to any of them. And I also want to thank the judge for his kind introduction. He is right that none of you probably were of age when I was working in the government and wrote a few memos, but I think you were probably all in high school when I kicked Jon Stewart's ass on The Daily Show, so you should remember that. Or many of you, I hope, are still listening to the Law Talk podcast on Ricochet that I have with Richard Epstein. And so those of you who do listen to that know my job on that podcast is just to interrupt Richard every 15 to 20 minutes. I'm actually not going to talk so much about originalism and executive power, but I'm going to try to make the transition from that to modern controversies. And what I'm going to argue actually was just a small point I thought I was making in a piece that's going to be coming out with the Yale Journal on Regulation about national monuments, right? Took the position with my co-author Todd Graziano that the new president has the power to de-designate national monuments or reduce them in size, which I didn't think was going to be a controversial point about presidential power. But then 300 environmental law professors, I didn't even know there were 300 of them, 300 environmental law professors signed a letter saying that no president could actually reduce or de-designate a national monument, that the delegation of power in what's called the Antiquities Act is like a one-way ratchet, and once you designate a monument, it can never be undesignated except by Congress. Of course, I made the point that, well, what would happen if President Trump designated all the golf courses to be national monuments? That means no president will ever be able to undesignate them. And I said, don't tell Trump this, because we're going to have a lot more national monuments soon. So I was really surprised about this view that was widely held, and so we started to do a little more research on it, and I actually came to think that this is the real crux of a lot of the debates we're having about presidential power now. It's not the use of presidential power to expand the presidency. Actually, what Trump is doing is something I would have thought would have been inherent and natural in presidential power, but actually I think is quite controversial, which is the president's power to reverse. So that's the name of the article I'm working on with Sai. It's called The Presidential Power to Reverse. But like Marty, if anyone has a better title that will get it accepted by law review editors, I will buy you a free drink at the FedSoc bar if you can give it to us. So think about the different controversies, though, about this. What's the DACA debate over, right? Does President Trump have the right to reverse the use of prosecutorial discretion by President Obama? I just mentioned the monuments issue. Think about all the controversy. Does President Trump have the authority to fire the special counsel, Robert Mueller? That has to do with, right, does the president have the right to reverse a previous regulation by the Justice Department that places conditions on the president's own power to remove. Can the president terminate not just the Paris Accords, which he just did, but also can the president terminate NAFTA or even the WTO treaty? Does the president have the right to withdraw regulations that were issued by previous administrations or subject new ones to cost-benefit analysis that replace the old ones? So when we were thinking about this, we're like, well, there is this issue of reversal that seems to be the theme that's underlying a lot of these debates we're actually having about presidential power. And they're different in that the president's almost using these powers to shrink his actual effective political authority rather than expand them, which has been what past presidents of both parties have done. So why would there be a presidential power of reversal? And I would say in some ways it would be more extensive or vigorous than the other branches. So think about this. The other branches also exercise their own powers of reversal, right? We know that the Supreme Court reverses past Supreme Court opinions. Congress repeals past statutes with new statutes. In both of those cases, I think like the presidential power, there's nothing in the text that tells you how to undo the decisions of a past president or a past Congress or past Supreme Court. So we've always assumed that the way you undo it is by just following the same formal process that you use to do it, right? This is most clear with statutes. We don't have any provision in the Constitution that tells us how to undo a statute. We just, from the beginning, have naturally assumed you pass a repealing statute. But think about this. This is not true of the presidency. And this also, I think, is true from very early on. There are a lot of actions where the president and the Senate have to agree to do something, where we have assumed that the president can just act on his own or her own to reverse. So, of course, I think all of us on the panel have thought about, written about, argued about the Appointments Clause and the right to terminate executive branch officers. Think about that. The president, under the Constitution, has to get the advice and consent of the Senate. But when it comes time to reversing the appointment, most executive positions are reversed by single executive action, firing. Right? And now there are some people who have thought that Congress can place limitations. I hope you study such fascinating cases as Humphrey's executor and Morrison versus Olson and so on in your constitutional law, in the places where separation of powers is taught in constitutional law. Right? In those cases, though, Sai thinks he's the only one who teaches these cases. So, which may be true. So those are all cases where the sole executive power undoes an action which formally had been undertaken by the President and Senate together. Of course, there was a huge constitutional controversy about this with the Office and Tenure Act, led to President Andrew Johnson's impeachment, almost removal from office. It is really not settled by the Supreme Court in Myers. Not really fully settled because we're still fighting about it today. Also, think about treaty termination. That's another decision. The president has to get the advice and consent of the Senate to make a treaty. But however, the president can terminate a treaty by himself. Now, that might have been controversial at the founding. It certainly doesn't seem to be controversial now. Congress has actually terminated treaties by itself, too. But we don't follow the same formal process to undo a treaty that we use to make the treaty. So we also, I think, when it comes to the presidency, even have come to assume this has to do with presidential policies, and I would say even foreign policy. So Marty just mentioned the peace treaty with Great Britain in 1783. I actually think the more interesting and worth a lot more study than it's really gotten has been America's treatment under the Washington administration of the Franco-American Treaty of Alliance in 1778. Well, this was a very bad idea to ever have a treaty with France, I admit, but we made that crucial mistake. France actually was critical for our independence, right? Remember Yorktown and the French fleet offshore. Now, when the French Revolution occurred, and every nation in Europe did invade France, I think the French quite reasonably sent an ambassador who showed up and said, well, you know, we bailed you out in the 1770s, 1780s. We'd like you to return the favor. We have a mutual defense treaty, so we'd like to start outfitting privateers, and we'd like to basically build a navy on American soil and start attacking the British with it. Right? You would have thought, and there was a great debate in the Washington cabinet about whether to obey the terms of the treaty. I think the French are still angry about this with us, but President Washington, what did he do? He declared neutrality. he effectively changed the foreign policy of the United States as it existed under the Continental Congress, under the first presidency. Although we've had a huge debate at that time and since about control of foreign policy and who gets to declare neutrality, I should add that Thomas Jefferson nor Alexander Hamilton disputed that it was the president's right to make that decision. Now, they argued about where the source of it came from and how far it could go, but neither Jefferson or Hamilton in the cabinet thought that it was Congress's decision about whether to declare neutrality or not. But it should be, I swear that in a way, Washington was not just setting foreign policy, he was reversing the foreign policy of a previous government. So, like I promised, I'm going to be short. I'm actually going to be, I want to point out the person who ended earliest of my co-panelists because I'm so eager to get to questions from the audience. I just want one last point, one last historical example, the Emancipation Proclamation, or even the decision to use force in the Civil War. President Buchanan had the same, by the way, President Buchanan is rated the worst president in American history. Of course, his descendant, Pat Buchanan, would have been even worse, but it's actually James Buchanan we're talking about here. No, there's some people saying, no, Pat Buchanan would have been great. So, wow. So actually, so Buchanan's view was that secession was unconstitutional, but he thought the presidency had no constitutional authority to stop it from happening. Lincoln came in, right, immediately decides that he can reverse that policy, even reverse that reading of the Constitution, which Buchanan had published in all the national newspapers leading up to secession. So I think that actually not only does this theme underlie a lot of our modern debates, but I think it's actually something that's the core of the presidency and the core of the executive power, and that no president has the right to bind future presidents in the use of their presidential powers. So thank you very much, and it's great to be here. Can I just make one nostalgic note that this is so great to see all of you here. I remember when I was a member of the Federal Society at Yale, where we hosted the Student Symposium 25 years ago, and it was a lot of work for all 9 of us in the society to plan the conference. You laugh, but this is true. But I do want to say that Cy was a member of the Federal Society at that time. David Bernstein, who's here, was a member this time. There was some joker named Caleb Nelson who was a member of the society at that time. And then there was this guy who sat in the back who was at all the meetings but never said anything. I said, what is ever going to happen to Chris Wray? Oh, he's the FBI director, in case you're wondering today. So thanks very much.
Before we get to questions, does anyone want to respond to anyone else? And I'm going to try to keep you to 2 minutes. Yes, go ahead, Mark.
Yeah, just a friendly response to John, and I agree. The Constitution, I usually say, is like eHarmony. It's very good about getting you into relationships. It says very little about getting out of them, and so removal, treaties, etc. But, I think the thesis that the president can remove, can reverse him or herself depends on what power you're talking about. And so when we're talking about treaty termination, and I think John even slightly acknowledged this, and there's a very good article by Kurt Bradley on this, that at least at the time of the founding, and really almost for over 100 years, both the original understanding such as it was and then the ongoing practice was for either the Senate or at least Congress to in some way substantively participate in the termination of treaties, and that falls out as the executive gains power as the United States becomes a greater world power. So, and in fact, I wouldn't say that it's settled by any means. Goldwater versus Carter, the court sort of ducked it. The argument of my book is this is exactly the kind of case the court should take. And who challenged the president's ability to terminate a treaty? It wasn't, liberals in Congress. It was Barry Goldwater. So that would be my friendly amendment to the thesis that the president can reverse something he does. It really depends on what the power is you're talking about, and if you are going with some version of custom and original understanding, there are some things that are not going to be deemed exclusive presidential powers.
Thank you. Anyone else?
Let's go to the questions.
Okay, great. So we're going to go to questions. I know you're all smart because you're here, but we want you to truly ask questions, so I will interrupt you if it's a statement, not a question, okay? All right.
Hi, my name is Timothy Seiler. I'm from Florida State University. So we're talking about executive power here, and there's a lot of statements made about the proper role of the executive, but what I'm concerned about mostly whenever I'm looking at these cases is when the legislature is acting in complicity with the executive, so that they're voluntarily abdicating their powers because it makes it easier for them to maintain office, or just turn a blind eye to things like the invasion of Libya, or numbers of war powers are a great example. What is the role of the judiciary in trying to restore that balance when the two other branches are acting together to violate the Constitution in that way?
First of all, let me, I quite agree with you, with the premise of your question, and I think it's a terrible mistake to think that the purpose of separation of powers is like the Congress benefits, is like from things that are allocated to Congress, and the president benefits. Oftentimes, Congress doesn't want to exercise the responsibilities that it has, and there's the Declare War Clause, I think, is a classic example of this. They may want to duck responsibility. It's clear that they do duck responsibility today, but the whole point of the Declare, or at least a lot of the point of the Declare War Clause, was so that they wouldn't be able to duck responsibility. Now, I have to say, I'm curious what Martin will say, but I'm very skeptical of the ability of the courts or the capacity of the courts to be able to wade into that.
Well, I mean, I think if you go back, to Youngstown and Jackson's categories, he talks about Category 1. He doesn't say that the consent of Congress, that the action's automatically legal. He actually leaves a window open for saying it's illegal or unconstitutional. So I don't think it has to follow that the courts aren't going to be involved. I think the question is whether, whether there's some individual right involved, right? Even though the president and the Congress are acting in cahoots, is someone injured by that? And if they are, the courts can intervene. And that's the tricky question, right? When members of Congress just try to sue the president because they think he's done something unconstitutional, I think the traditional view of the courts is that they don't have standing to challenge that. But if you're adversely affected, if you're injured in fact, et cetera, by a situation where the president is acting pursuant to statutory authority in a way you think is unconstitutional or illegal, then you would have standing, and that should be adjudicated, it seems to me.
By the way, Jackson does say that it's in Category 1, that it's only unconstitutional if the entire nation as a whole could not do it, which I think throws out the separation of powers problem. Jackson is wrong about that. And it's not the only one of his three categories that he gets wrong. He gets all three of them wrong.
Including the number of categories. I'll tell a story and then a real point. But I quite agree with you that what you see in the war powers area is Congress wanting to abdicate political responsibility, maybe constitutional responsibility, but certainly political authority and responsibility, and delegate it to the president, which is so different than what Congress does in every other area. So personal story. So when I was a 34-year-old Justice Department official, we were thinking about invading Iraq. And so people from Congress called over and said, could you come over here and write for us the statute authorizing the use of force in Iraq? And so I had been also a Hill staffer, and I was like, I thought that was your job. But we're happy to do it, don't get me wrong. So the Justice Department officials say, hey, you. Well, they didn't say, hey, you, but they could have said, hey, you, John, you. Yeah. Actually, that's kind of how Ashcroft operated. I mean, said, why don't you write it? I hear you know stuff about war power. So I drafted this very plain vanilla authorization. And then a senator who will go nameless because, unfortunately, he hasn't died yet. Yeah. So he's still around. So he called over and he said, come on over to the office. So, me and one other official from the White House go over. And he says, I want to go through this with you. What does this word mean? What does that word mean? And I was like, Senator, you're the one who's actually supposed to be drafting and passing this legislation. What do you think it means? And he said, I don't know what it means. And he said, why are you making us vote on this? And I said, we're not making you vote on anything. It's your authority to declare war if you think that's what you can do. So this is my personal story. The whole thing has moved so far over that the legislature actually asks the executive branch to draft these supposed strong constitutional checks created by the Declare War Clause. But the serious point is I don't think we should be wary of interpreting the Constitution or changing its meaning to solve a political problem. I mean, I agree that there's a political problem if Congress wants to delegate and not make decisions on war. But does that mean we have to read the Declare War Clause to be broader than its original meaning, or to read the Commander-in-Chief and Executive Power Clauses narrower? I think a lot of the arguments you hear run along those lines. I would say, look, the Congress is complicit in all of these decisions. I think the main check on presidential power is the war power. It's the funding power. See, Marty's brainwashing me already. It's the funding
It
power.
only took 15 years.
15 years. It's a lot faster than most other people. So, no, it's the funding power. We have a military that's designed to be offensive in nature. It's designed to wage war in other people's countries. Who paid for and built and consistently built it over 50 years with the agreement of both parties, right, over a long period of time? It's Congress, and then Congress won't vote on any kind of authorization, usually, and then they're going to complain when the president uses a military that's designed to fight overseas. I think it's just like what you see in the administrative state. Congress delegates huge authority to the president. They issue regulation, and then Congress complains about the regulation so they can get reelected. But I wouldn't say that means we have to reorder the constitutional system to solve that problem either.
By the way, something John said points out an important reason why these problems have come up in modern times more so than they originally did. We did not have this kind of modern standing army, this fighting force. When Adams thought he was going to war against France in the Quasi-War in 1798, he had to go to Congress, and they passed a law allowing him to recruit a 10,000-man army. So in that case, appropriations come before war, but once you have the kind of military that we have, and I'm glad we have it, but it does mean that the president is able to go to war first, and then I think that the funding power is a lousy check because Congress does not want to have our fighting men and women over there and cut off their supply. It's the worst possible way to check the war power.
But Mike, isn't that a political problem? You could say the framers would have thought, until 1945, the framers, if they thought, as I argue, that the funding check is the check, it was a perfect check until 1945. And then the president and Congress reordered it. But then it wasn't that the funding power failed, it's just the president Congress chose to use it differently. And then I think a lot of scholars, I agree with you, make this point, well, it's hard to cut off funds, but isn't that a political problem? It's not a constitutional problem.
Well, I agree it's a political problem, but that doesn't make it go away. There is one other check, by the way, that has failed, and that is that the lawyers in the executive branch have an obligation to tell the truth about what the Constitution means. And if anyone has read the OLC opinion justifying the war in Libya and was impressed and persuaded by it, I'd be surprised. And then the claim by the counsel of the State Department that it not only is it not a war for purposes of the Constitution, but it isn't even a conflict for purposes of the War Powers Resolution, really deserves a particular place. When the executive branch lawyers don't do their proper job of saying no when the president is trying to do something, we've lost in a very important check.
I must say I'm enjoying some of the disagreement here from an ACS point of view. It's divide and conquer. But so sort of 2 points. I agree with the premise of your question as well. And the first point is to show you how far we've come from the instincts of the executive branch. It goes a little bit to what Mike just said, which is one thing John skipped over with the Neutrality Proclamation was when it came time to interpret that treaty of alliance with the French, the instinct of the Washington administration, supported by both Hamilton and Jefferson, was to go to the Supreme Court, even though there wasn't a justiciable case, to say, please interpret this for us. Do we have obligations under this treaty to defend France or not? And it was the Supreme Court that refused under the cases or controversy doctrine to weigh in. So that really shows you how far we've come in this sort of instincts about exercising executive power, even in foreign affairs. The other thing I'd say, and this to me is a truly historic occasion, I can say wholeheartedly that I agree completely with Prakash, which is to say, and I'd be interested to hear what the panelists have to say about this, I think it's the Smith case of this officer who is bringing a challenge to the operations against ISIS, because it seems to me the idea is, it's really, if the executive branch is operating in an area where the executive branch needs congressional authorization, and let's just stipulate for a moment that it does, that would be to be decided, and then someone's right is being affected, in this particular case, an officer who would be deployed there and put in harm's way, and let's stipulate for a second that something like that meets standing requirements, I see no reason why the courts should duck that, assuming those two stipulations. Now, we could challenge those two assumptions, but I think assuming those two things, I think it's the duty of the courts to step in.
Thank you, gentlemen.
Hi, my name is Ryan Williams. I'm a freshman undergraduate at Waynesburg University, and my question is for all the panelists. What are your thoughts on whether the Comey firing could be an obstruction of justice?
Judge?
And he's talking about that joke.
I am very skeptical of this claim. I think that even if you grant that theoretically, there's no doubt the president has the right to fire the FBI director, right? The only claim is that perhaps when there is a bad enough motive for doing it, that it becomes a matter of criminality. But the president can offer any number of facially plausible explanations for doing this, and I don't see how any prosecutor could ever look behind them. So it just seems like a dead end to me.
I mean, I think there's two ways of thinking about obstruction of justice. One is in the impeachment context, and of course presidents have been impeached for obstructing justice. And so I think if the House believes that the president had corrupt motives, I think they could impeach him for firing Comey. I don't think it'll go very far in the Senate, no matter what happens to the Senate. In terms of a prosecution, you know, most people don't think the president can be prosecuted while he's in office. And I think most people don't think he can be indicted, although I think there's a memo from the Starr investigation saying that he can. I agree with Michael that it's going to be hard to prove that he acted with corrupt motives. My recollection is he was very upset with Comey because Comey wouldn't tell the public what he was telling Trump in private, which is, you're not a subject of the investigation. And he told him that 3 times apparently, or he asked him 3 times to do this, and Comey kept on saying no, or just didn't do it. And you know, the president can act impulsively, especially this president, and I think he just was fed up with Comey for not making clear to the public that Trump wasn't a subject of the investigation. Ironically, firing Comey has made him the subject of an investigation, right? But I think, look, Trump is a Rorschach test for America. If you hate Trump, you think that he's violated the Constitution and the laws of the United States every single day, every single waking moment of his life. And if you love him, you just think he's, you know, infallible. And that's what's going on here, right? People are just constantly saying everything he does is an obstruction of justice. And there's a separate question about how do you apply the statute to the actions of a president or to a prosecutor, right, in a criminal trial. If a prosecutor decides not to bring a prosecution, is he guilty of obstruction of justice if you think he has some quote corrupt motive. I don't know if there's any case like that. There's certainly no case of a president being prosecuted for obstruction of justice.
Actually, interestingly, I think this links up with the last question about congressional accountability versus how we reorder the constitutional system today. Because I agree with Mike and Cy, but I would go farther than them in the sense that I think it doesn't matter whether it was obstruction. I think the House could impeach Trump anyway, even if he had the purest motive, because they don't think he should have removed Comey. And I think the impeachment clause, when it talks about high crimes and misdemeanors, we have misread it to mean it has to be a crime. I think that the impeachment clause was meant to cover a much broader class of offenses. They're not even offenses. All right? The Federalist paper calls them political offenses. And it's not just that they're political in nature, they're actually in some ways not really suited for the criminal justice system. But I think, and this goes to the last question too, about from that guy from Florida State, which I hear has a football team. So this is...
Not very good anymore.
I wasn't going to say it because I'm from Cal, but... So the last question was about, we've had a change in the political dynamic, and now Congress is trying to avoid responsibility for taking tough decisions. So shouldn't we, in a way, bolster other parts of the Constitution to correct for it? I think that's a mistake, but that's what's going on here too. I think the framers thought the impeachment clause would be used more often than we've used it, and for a broader class of actions by president. It's possible what Trump did would fall within that. That's up to, as I said, the House's judgment. But to cure the fact that we don't use impeachment clause because it's politically difficult, we have created this monstrous independent counsel idea, which I think is really undermining the presidency and the separation of powers for both Democratic and Republican presidents.
Martin, do you have any?
I'm going to end there because people are applauding.
Well, this hasn't happened to John in a long time.
Well, now I am silent. Actually, I was going to say I agree with John, but not on that. What I agree with John on is that high crimes and misdemeanors does not mean criminal offenses. I think it means abuse of power in office. That said, I do disagree with John on what you've just applauded, which is I think that it's precisely because the executive branch is so monumentally larger than it was in the 18th or 19th century. And that, one of the imperatives of separation of powers is some sort of fracturing of power and balance of the branches, that where certain constitutional devices are no longer up to the task of keeping this behemoth in check, we need to develop other things to remain faithful to the more general vision of the founders as opposed to the more particular. I mean, the irony is if we remain faithful to certain particulars, we wind up actually coming to a result that's 180 degrees different from what the founders would have wanted.
Over here.
I'm Matt Butler. I'm a third year at Yale. I was interested, Professors Prakash and you and others maybe in reaction, if you could say a little bit more about this executive power of reversal. So one thought is that it's the default. So in general, if you get a power, you can also reverse it. But then there's a deeper question, which is, let's say even in regulations, Unitarianism says you have to reverse things. But if there's a statute, could, for instance, the monument statute have said the executive can designate things a monument, but it takes Congress to reverse it? Can they actually, sort of cabinet in that way, or does that undermine some sort of fundamental power that you're arguing is there in the Constitution, implicitly maybe, to reverse as well as to enact?
Me first. So you can tell this article is very early in development because I don't know what Cy thinks. But my view would be that I think you're right that if the Congress, because when the monuments or some other regulatory power, since the constitutional system says that what the president's really doing is exercising delegated authority, and we're pretending there's no non-delegation limits to that, then I think Congress can condition and describe how the undoing of it is to be done. But as you probably observed, most statutes don't delegate to the president and then tell him how to reverse even the use of delegated authority. They're usually silent. And so what I was arguing is that the president's power to reverse his constitutional decisions creates this presumption that when Congress hands over this delegation and doesn't say anything to him or her about how to undo it, it's assuming that that same reversal power will be in existence. This was a big fight, not just with mines, but when the Reagan administration came in, actually there were a number of people who sued and attacked the Reagan administration's deregulatory agenda by saying the President Reagan the Reagan administration essentially could not undo existing regulations, that they were a kind of one-way ratchet. In this case, made it all the way up through the D.C. Circuit. It's kind of actually what's really going on behind the Chevron doctrine, I think. And so in the end, the D.C. Circuit and ultimately Chevron, the court said, no, you can use the same process to deregulate as you used to regulate, even though the delegations never mentioned how you would undo a regulation.
So John and I are law nerds. We were talking exactly about this yesterday. John forgot. And we came to the same conclusion.
Well, we were on two ellipticals next to each other, and I can't believe Cy actually even exercises.
Right.
And
Was he wearing his John Hughes
he
shirt?
was wearing the superhero shirt.
So look, if Congress wants to say that if you can't reverse this decision, it can if it's a statutory question. But if it's a constitutional question, unless Congress has authority over the constitutional area, then it can't say that. So John didn't mention this, but we did talk about this too. John's forgotten a lot of things in the past 24 hours. The pardon power can't be reversed. If he issues a pardon, he can't change his mind, and the next president can't say, I'm going to reverse it, right? Because once it's issued, you're basically free and clear, if it's an unconditional pardon. So there are examples where either the Constitution or Congress can make it clear that the thing can't be reversed. But I think our claim is in the absence of something like that, then the ordinary rule be the president could.
Oh, there was one more. Oh,
May I just say, I'm not at all sure. I mean, I agree with both of you that in the absence of legislation, that this is fairly clear. And of course, presidents have reduced the size of monuments in the past. And I think it should be at least a very strong presumption that every act of government that does not create when there's a vested right created as by the pardon, that's a different matter. But that acts of government can always be reversed by the way in which they were enacted. I'm not sure that Congress has the constitutional authority to say that future presidents are disabled from exercising power that has been delegated to a president. It's a hard question, but and it's never come up. But I'm very skeptical of that. I think presidents have. I think Congress doesn't get to pick and choose what president exercises the powers that are granted to the presidency.
The gentleman right there has been waiting. Go ahead.
I think he was first.
Was he?
Yeah.
Okay, I'm sorry.
Hi. This question is for Professor John Yu. I appreciate your insights breaking down the dichotomy between the war powers, the separation of war powers. My question is, how likely is President Trump's view shaped by his previous predecessors in terms of the legacy that he's going to hold for future younger generations? And this is in reference to war powers, peace powers, for the much anticipated meeting between Kim Jong-un coming in May. And go ahead.
So it's an interesting question. I wasn't prepared to discuss about the. I mean, I could have said, not only should the list of reasons for tariffs be short, but it's also the list of reasons to meet the leader of North Korea. But I'm very surprised that the president has decided to, elevate the leader of North Korea to the level of the president of the United States, essentially, by agreeing to meet him almost immediately. I mean, this is extraordinarily fast well, this is the State Department we're talking about, but it is extraordinarily fast for diplomacy to say we're going to have a summit meeting in May with the head of North Korea, given all the issues that have occurred. On the other hand, John Bolton was on TV last night saying that this was a benefit because we can finally figure out for whether North Korea really is going to disarm in exchange for a reduction in sanctions or not. I tend to think that's a foolish hope. I don't see why North Korea would give up its nuclear weapons no matter what we offered it. I think that might be the unfortunate lesson of the wars in Libya, Syria, Iraq, and so on, is that if you're a oppressive authoritarian dictator and you don't want to be attacked by the United States, don't give up your nuclear weapons, no matter how bad you're running your country. We've never attacked another nuclear-armed country since World War II. So in terms of the broader question about the panel, though, I think I detect like Marty and Mike have a more pro-Congress view, I think, of foreign policy. But I think just the fact, I think this shows what President Trump, as the president, his constitutional authority is to run foreign policy. I don't think anyone really is saying, oh, he shouldn't have that meeting, and Congress is the one who decides whether we're going to have, diplomatic exchanges with North Korea. We have come, I think, because of the Neutrality Proclamation, and ever since, we've read the Executive Power Clause to give the president that authority.
Yeah, just very quick. I mean, one is no, we haven't. I mean, I think there's a big difference between the president running foreign policy, right, and then the president, negotiating with, heads of foreign states. I agree with John on the wisdom of doing it, and I'm very nervous about the risks if this goes wrong. But I can think of at least two constitutional powers, specific constitutional powers. And footnote here, this was the style of argument that Hamilton actually adopted in the Pacificus Papers. This one little stray point about executive vesting clause also gives undifferentiated, is kind of a throwaway line that everyone has seized on since. What are the two powers? One is the power to make treaties. I would say that involves the power to negotiate treaties. The other is, arguably receive ambassadors, or even beyond that, just I think a more specific original understanding that the president would be the sole organ of foreign affairs. What did that mean? That didn't mean run foreign affairs. Even Sutherland really didn't say that. It meant being the point person for contact with other foreign governments. So I can think of at least two constitutional powers, one based on text and one based on a more specific vision of original understanding that would empower the president to do this. Whether he should or not is a whole nother matter.
Last question.
My name is Horacio Marquez, and I'm in international finance. I'm not a lawyer, but I stayed in many Holiday Inn Expresses. So, at the risk of putting my foot in my mouth, Professor Yu, with respect to your article about reversals, why get hung up on the term reversals when really any new legislation, even when you call it reversal, doesn't bring you back to the point of origin, because the entire world has changed, technology has changed, economics has changed, and you've, after regulation has been implemented, well, I'm going to, in the world of finance, Sarbanes-Oxley, which is law, not regulation, has had a tremendous impact, and we have learned many of the negative impacts of Sarbanes-Oxley. For example, small companies that had to go private and couldn't list in markets because the cost of complying with Sarbanes-Oxley became prohibited. Companies like Dell went private, for example, and to avoid those costs. So since we had the hindsight of history that teaches us how to re-regulate. And
sir, we're running out of time,
yes.
So if you have a question, ask
why
it.
call it reversal instead of, say, sublimation or new? If you could all comment,
So
I appreciate your perspective.
Point you raises this thought experiment that Mike's comment also raised, which was, and this has to do, I think, with a lot of financial regulation, because although you're right, Sarbanes-Oxley or Dodd-Frank are the statutory expansions of regulation, it's really the agencies which have really been heavily regulating in the securities area. Right? Like when I was in law school, we spent all this time on something called Rule 10b-5. I was very disappointed to learn that Congress had never passed Rule 10b-5. Right? It's done by the SEC. Right? So that's the fundamental bar on insider trading. Right? So what if a president like Trump came into office and on January 21st, 2017 said, I hereby repeal all regulations and return all executive branch made law to the state it was in on January 19th, 2009. Could a president just do it all at once, repeal, pull, whatever you want to call it, repeal, reverse, and could a president just do it simultaneously for every regulation and just say, I'm just returning, and that's what your point is about, returning it to the origin point, the status quo as was before my predecessor was in office. I think he could, unless, and then I think the interesting point is whether Congress could try to stop him from doing that.
So I don't think he can. I think Congress already did stop him when passing the Administrative Procedure Act. And I thought the principle that all of us were agreeing on is that the backdrop is reversing a decision is done in the same way that the initial decision is done. Those regulations were all instituted through notice and comment rulemaking, subject to a variety of procedural checks. I think they can be reversed, but only through notice and comment rulemaking and going through the same gauntlet of procedural checks as before. This is why this DACA case is so bizarre, is that President Obama did not go through notice and comment rulemaking in this immigration matter. He was supposedly exercising prosecutorial discretion, and now the courts have amazingly said that President Trump can't exercise the same prosecutorial discretion the opposite way, which is, I just think, a great mystery.
All right. Before I tell you to thank the panel, I want you to stick around for a minute because we have an announcement, but please thank the panel.
Always fun.
I know, I missed
We should get the road show.
And thank you, Judge Thapar, and all of our panelists. One quick announcement. We are missing a coat. This is a black Ralph Lauren ladies' coat, so if you happen to grab the wrong coat, take it up to the registration tables, if you will, please. We're now going to take a lunch break until 2 o'clock. You can make your way up to the McDonough atrium where there will be food. We also have plenty of events to keep you entertained while you eat. In McDonough 200, we have a panel discussion over becoming an academic, hosted by Lee Otis and featuring some of our favorite members of the Academy. In McDonough 203, we have a panel discussion over our lawyers chapter, moderated by Lisa Ezell and featuring practitioners from various and distinguished career paths. Both of those panels will be starting here in the next 5 minutes, so hurry up. In addition to those, Ed Whalen will be doing a book signing of Scalia Speaks in the McDonough atrium, not far from where you'll grab food. So have a great lunch, and we'll see you back here at 2 o'clock.
There's no lunch till 2.
No, it's at 12:30.
Did he say something? Did he say the opposite? No, I misunderstood. Oh, yeah, right.
Do you know this assumption about rulemaking? Hey, John.